then the pressure will be on IBC to make sure that their processes are above board. There's no two ways about it. And if you look further, the way the Supreme Court of Malawi elaborated that case in the case of Mutharika, they went authoritatively beyond the Kenyan Supreme Court. First of all, they agreed with that law and that jurisprudence and rejected every other jurisprudence in Africa on that single issue. But they said that the Kenyan law was the correct law. Now, the pressure then is on IEBC to make sure that everything then tallies. Now, if you remove individuals from the presidential contest, this is one thing that will help strengthen our electoral processes moving beyond 2022. The second issue where the Supreme Court got it right was the whole question of burden of proof, where they say that under the common law practice is simple, that whoever alleges must prove. In 2017, the Supreme Court adopted the position that the petitioners had all the rights to adduce evidence of election irregularities. Now, in courts, constitutional courts and Supreme Courts in Africa, that burden does not shift to the respondents. Now, the Supreme Court adopted the position that once they were satisfied that the petitioner had adduced and discharged that burden, then the respondent had the onus of disapproving the allegations that were made. If you get time, just Google simple questions that the lawyers, advocates could not answer in 2017. You will see the IBC advocate grappling with the so-called statistics, that what was projected in Bomas were just statistics. There is no terminology anywhere in the world where an election is regarded as statistic. And you will see evidence of how the respondents were completely unable to discharge or rebut that burdens. Now, if we continue with this, this is progressive. Finally, is the question on the standard of proof. Is it on a balance of probabilities? Is it on beyond reasonable doubt? Now, the Supreme Court of Kenya adopted a position that the standard of proof is somewhere in between. And the Supreme Court of Appeal of Malawi rejected the Supreme Court of Kenya argument on this. And they said that an election petition is a civil proceeding, and that the applicable or the relevant standard is not an intermediary standard like the Supreme Court of Kenya said, but that it is a standard, it has to be on a lower threshold, and that is on a balance of probabilities. I think on this one, we had the privilege of retreating the Supreme Court in Nakuru to look at their decision in 2017, and you are able to flag this issue, that moving forward, they would have to consider this. Now, ladies and gentlemen, in conclusion, let me say this. What the judiciary has tried its best. And moving forward, I think what all of us as civil society needs to do is to try and strengthen the resilience of the judiciary so that we don't experience what we experience in this country, where we make steps forward, but then makes even more steps backwards. As LGR, what we are doing, we have engaged with the IBC and the Parliamentary Committee on Justice to look at the questions of electoral reforms, but we also have a very robust program with the judiciary on strengthening the electoral dispute resolution in Kenya. Thank you very much, and my apologies if I took long.
Okay, thank you very much. Because we are still in the arena of the courts, then Christine, I want to apologize for ambushing you, but to thank you for your indulgence. It was mentioned in the morning that part of the challenges around recruitment of the CEO of IBC has been, litigation, people going to court. But we like to see the courts as a force for good and a place where justice can be addressed. So just if you can briefly speak to us a little bit about public interest litigation and the place of that in ensuring that we have electoral justice, or at least we have some reforms in place. You can use this mic just where Felix was. Makofi, please encourage Christine because I've ambushed her.
Thank you, Regina. Hello. Oh, sorry. This is yours?
No.
Okay.
Oh, actually, let me see.
Okay.
This bad handwriting is mine.
Okay. Thank you, Regina, and I'll speak very briefly to this issue. And just to pick up from where Felix has said, for me, when you're looking at legal reform and where we are now post-2017, the first question is asking, how has IBC demonstrated that they've taken the lessons from Raila 2013 and 2017? What is the communication that has been coming from IBC on what they have done to ensure there is no invalidated presidential results come 2022? Have they demonstrated through their directives, through their communications by their chair, that they have actually internalized, but not only internalized, but actually implemented the decisions that are coming up from Raila 2017? Because I'm not sure that has been well communicated to the people. And I'm not even sure whether other court decisions that have a bearing on how IBC should conduct elections have been implemented. The two-thirds gender rule that is actually supposed to be applying now that parties are going to party primaries and then to create party primary lists. Political parties internalized, they need to have a gender-compliant party list. Have those discussions taken place with IBC and political parties so that come Feb and March 2022, there is no dispute around issues to do with party list and that the fact they need to be gender compliant? What have we done in relation to the minor KI case on ensuring, presidential elections are certain, results are certain at the constituency level, which came up again in the 2017 Raila decision? There have been some advancements in the law which have not really now been reflected in the text of the law, which makes things a bit unclear. Because if you're not a legal practitioner and know about jurisprudence, you read the election laws and other laws that have been amended through court jurisprudence, and the old text remains. This continues to create, confusion, and that is the place of public interest litigation. The minor KI case was a public interest case. And I think one way to avoid so-called busybodies is to ensure adherence to the letter and spirit of the law. There will be no one going to court if duty bearers adhere to the spirit and the letter of the law. But as Caroline has said already, of all the plethora of laws pending to affect the 2022 elections, there are some that are positive and some that are negative. Kenyans who have already enjoyed a measure of democracy, do you expect us to sit back and allow these negative reforms to take place? Of course there will be public interest litigation, and that is precisely why the 2010 Constitution allowed citizens to be active participants in their own futures, in their own lives. So I think we need to internalize that we now have Articles 22 and 258, and citizens will be active participants in Kenya's democracy, and to defend the democracy, the gains we've had so far. So again, another reason why there's usually public interest litigation is where governance is not open. If you make decisions that are not shared in public, and when citizens make access to information requests on procurement of election materials and resources, I expect there'll be another Al-Ghurair situation. If access to information is not adequately adhered to, and we don't have open systems, because we know our history. So when information is not shared, people will think that something is cooking in the background. So if there is more openness, these fears might not be founded, and maybe we not need to go to court to try and find out what is happening. So sharing of information is crucial. Public participation when you're making directives, regulations, and laws, other things that might not be legal reforms but are rooted in statutory foundations, those are necessary. Trying to push laws very close to the election is also an issue of public interest, and could generate public interest litigation. I foresee public interest litigation, a lot of it, from February, March, which will then affect the preparedness for the duty bearers. And the rationale behind having in-laws in place at least a year in advance is at least litigation will have ended 6 months too. And then now you not have these issues of people scrambling to meet their obligations because court cases have come late in the day. Again, that is all a process, I think, if we plan, and we know we are in a litigious country, we plan in advance, we do this in advance, so if they should end up in court, the process is complete early in advance to the election. Because as I think one of us has said, if we plan to fail, we will fail. And we can't say it's not intentional. We know we have a set electoral date that comes every 5 years. So why are we doing things last minute? Because they will lend themselves to public interest litigation. And public interest litigation is not meant to make anybody's life difficult, but actually to uphold the letter of the law and the spirit of the law. That's what I'll say on that.
Thank you very much. Last but not least, and we still have my learned friend here, Dr. Shem Ochuodho. Just give us a brief input. We hear the voice of the diaspora, so we're going back to the people. And I hope you can see the connections between the different topics we have discussed and how all lean on each other and depend on each other.
Regina, diaspora is the forgotten Kenyans. Even now, for them, we just want a little. The last time we were trying to get MPs to assist diasporas to vote, one told us, forget about those guys. Let's deal with our issues here. It's in that regard that allow me to recognize that they are part and parcel of the Kenyan DNA. Diaspora at least gave not only Kenya but Africa technology that we use today that's called the internet 26 years ago. And with a light touch, I know COVID is ravaging. The Kenya's diaspora have come up with what I believe is the best remedy for COVID. More than 10,000 people who were positive have turned negative within 2 days, and it's available in Kenya as well as 19 other countries. So these Kenyan diasporas are very much part and parcel of our society. It's very difficult to talk about technology, and allow me, because I sit between that nexus of technology and the diaspora, without mention of Chris Msando, particularly if we are talking about electoral technology. I recall about a few years back, let me not say how many, a former chairperson of a precursor to Ibc did visit our colleagues in the US, and a product solution some of you may be aware of, M-Vote, M-Kura, and so on, was demonstrated to him. He looked at it and loved it. Very secure. Now it's actually backed by blockchain technology, as secure as it can ever be on Earth. Then blockchain wasn't there yet. But his answer, he said, this technology can never be used in Kenya because it's too transparent. The question that somebody asks, you'd have thought that we needed a transparent, fair, accurate, and timely system. But that was not to be. Let me just mention as I leave that, among the bills also in Parliament, I think there's one by Honorable Godfrey Osotsi, the Ict Practitioners Bill. Part of the problem with Kenya, the technology is an issue, but the people who deal with and handle that technology is also an issue. Technology is as good as the people who handle it. In Kenya, everybody is an ICT expert. That's problematic. I'm hoping that Godfrey Osoti's bill will help sort that out. If IBC utilized proper personnel, Kenya-known personnel, there's no reason why we should have the problems we are seeing. So I want to encourage my good friend Felix not to fear technology, because that's the way of the future. He receives M-Pesa with technology, but enough for technology. A quick shift to diaspora. For us to have free and fair, credible elections, some of us feel that the 30% of Kenyans that are disenfranchised have to be enfranchised. Half of them are the 4 million Kenyan diaspora. The other half are the youth. There was a little attempt during the enhanced voter registration that didn't go too well. Of course, we can't say in this meeting sufficiently why that was the case, but still about 15% of Kenyans are disenfranchised who need to be registered to vote. In the case of the diaspora at the moment, there is an Ibc team that's visiting US and having conversations on how best to get diaspora to register to vote, possibly in January. But there are handicaps in the past that have not made it easy for diaspora to be registered to vote. And I must compliment ILOG and Uraia in the past. We've worked together to mainstream diaspora in this journey, and we still remain to do a lot more of that. Although there are 4 million Kenyans who would register to vote outside the country, my estimation at the very best, if we get 100,000 register, would be very lucky. And there are many reasons for this. Let me just mention a few. First, beginning with next door, because we started registering Kenyans in the neighborhood. Personally, in 2017, I traveled from Juba to Nairobi trying to register. It just closed that day I got in, so I had to go to Kampala. Kampala was still registering. Fortunately, this year, I understand Ibc is going to have registration in Juba as well. But while in Kampala, I saw 99% of Kenyans come wanting to register, being turned away. Reason? They didn't have valid passports. Normally, when you go to Jirani, Tanzania, Uganda, you rarely need an ordinary passport. So it's like the constitution is very clear. You can register with either a national ID or a valid passport. Why Ibc came up with this regulation, I'm yet to be convinced on it. Of course, they were saying they always have a reason. The ambassador, acting ambassador, then said this was the directive from Ibc. How do you know Kenyans are not crossing the border from Kenya to go to Uganda to register? But there are other ways of establishing residency, so that would have been used. The same in South Africa, although extended registration was made to South Africa, when you go to Pretoria, now called Shwane, most Kenyans are either in Johannesburg or Cape Town, Pretoria, and the like. Maybe a mobile system would have worked. This is what we are recommending even to the Ibc at the moment as they are touring the US. In terms of short-term possibilities, what can be, I'm trying to jump a few issues, can be done in our view. I belong to a group called Dialogue Contact Group that precipitated the handshake, as some of you probably know. They're looking into what should be the minimum, and some of what they're discussing resonate with what's being discussed in this conference. The capping of election finance, it may be too late, but I don't think there are many ways to get free and fair, credible elections unless that's actualized. Sorting out party nominations, and this also includes diasporas. Often we don't consider them as a special interest group. For nomination purposes, they need to be on the table. ANC, that's being used as a good example, actually has got 2 slots for members of parliament representing the diaspora. But in addition, diasporas who want to run for office, and for the first time, I think there's going to be a flurry of diasporas this coming election running for office. One handicap is if they were able to be cleared at the embassies, work would be much easier. They have to travel to Nairobi to be cleared and so on. It's quite a nightmare. So in conclusion, I must say that we're grateful. They say sometimes half a loaf is better than none. We do know that Ibc hides under the cover of the progressive provision that even if you added one more person, diaspora registered, after 5 years, you will have still achieved that threshold. The Supreme Court made a ruling very clearly in 2015 on what needed to be done for diaspora to register, but that hasn't been achieved. The only answer we see resolving this is technology. And again, I must reiterate the fact that an old mother in Turkana did not walk 50 kilometers to go and vote, while this could be securely done on their mobile. I think I'll rest it there, and thanks and congratulations to ELOG and the partners. Cheers.
Thank you. And thank you for being brief. And the forgotten Kenyans are never forgotten when you're around. So, Owie, I've given you a full plate of food to chew, and we're looking forward. It's up to you. You can stand there or use the microphone.
Thank you very much, Regina. Ladies and gentlemen, it's tough to be IBC, isn't it? Indeed, very tough. But we are there. We are there and ready to deliver, and hope that with the support of all the actors in the electoral sphere, we will be able to deliver and deliver very well in the general election of 2022. As earlier canvassed by Commissioner Molu, the mandate of IBC is quite broad. The Constitution, of course, provides the overarching mandate, that of conduct or supervision of elections and referenda. But then under Article 88.4, you find a total of 11 broad mandates that the IBC is required to discharge. The Commission has had to address questions as to whether it is prepared to conduct the 2022 general election. And I stand here to say that based on our assessment so far, the Commission is quite prepared. Of course, we have about 7.5 months to the D-Day. How is the Commission prepared? The Commission has developed a strategic plan that guides it for a period of 5 years on discharging its constitutional mandate. And drawing from the strategic plan, the Commission has developed an election operation plan, 2021-2022. A plan that is quite elaborate, detailed, and provides timelines and activities to be undertaken within those strict timelines. The elections operation plan has been shared and is a product of broad public participation. It was launched right here at Bomas of Kenya, and it is in the Commission's website for public access. So that far, the Commission has tried. The Commission may not be very, very perfect. Limitations are bound, and it's human to be limited. But it's also important that those limitations be addressed, and that is why the Commission continues to engage stakeholders in various fora, and one of them is this one. Now, ahead of the 2022 general election, the Commission has undertaken a comprehensive review of the electoral legal framework and has prepared a report that has been posted at the Commission's website. It is dubbed the Elections Experience, IBC Perspective. And it covers issues that have potentially been addressed here. In addition to the report, the Commission came up with a bill, the IBC bill, to amend provisions of the IBC Act as way back as 2019. The Commission also came up with a bill to address the gaps in the Election Campaign Financing Act 2013 and also developed regulations. Further, the Commission published what is called the contribution and spending limits on election campaign financing. We all know what happened with those regulations and the limits that the Commission gazetted. They were annulled by Parliament. So as it were, the Act is there, but without the regulations that essentially give effect to its implementation, implementing the Act is a tall order. Yet, it is one of the mandates of IBC under Article 88.4 to regulate the amount of money that is spent by candidates and political parties in an election. Currently, the Commission is at the tail end of drafting a bill with the assistance of the Office of the Attorney General, and will by Monday submit that bill to the Justice Legal Affairs Committee for purposes of processing and tabling before the House. I'm aware that the House has been summoned for a special session next week. Probably this is one of the bills that will be discussed by the House. Now, this bill contains proposals that are very, very fundamental in the conduct of elections. Beginning with the definition of terms, the Elections Act mixes up the definition of nomination. In certain parts of the Act, nomination refers to party primaries, the process by which political parties elect or select their candidates for purposes of presenting them to IBC for registration. In certain parts of that Act, nomination has been used to refer to the IBC nomination, which under the Constitution is defined as registration of candidates for election. So our proposal intends to make clarity on the definition of nomination, to separate party primaries as nomination and IBC registration of candidates for election. It also seeks to address issues on voter registration and a hot one on transfer debate during the continuous voter registration exercise and the enhanced voter registration exercise that just ended a couple of weeks ago. The regulations, elections voter registration regulations provide at Regulation 13C that for you to transfer your vote, you need to prove that you are ordinarily resident in a constituency. And that is in the regulations, but not in the main act. So we are seeking to provide a legal basis for that in the act. But then we are expanding that requirement to say that it is not just the proof of residence. If you can prove that you have business interests in a place, or if you can prove that you are under employment in a certain constituency, then you don't need to prove that you are ordinarily resident there. So we are seeking to broaden in the nature of being facilitative those grounds that can then allow a citizen to transfer his vote from one constituency to another. We are seeking to address the confusion around inspection of the register and verification of the register, so that it is simple, because the law provides that inspection should be continuous, but verification has certain timelines within which you should undertake verification, because it involves also the verification of biometrics of a voter. We are seeking to address issues on recall, and this is quite controversial. Controversial because the High Court declared as unconstitutional the provisions of the Elections Act on recall. Recall of members of County Assembly and recall of members of the National Assembly and the Senate. That was a case filed by Katiba Institute. And Katiba Institute reasoned that Article 104 of the Constitution contemplated a simple and easy to realize statute that should be enacted by Parliament to provide for recall. Yet Parliament enacted an act or a provision that made it, in fact, nearly impossible to realize recall, because it involved going to the High Court, filing a case in the High Court. Of course, there are timelines. You cannot file a recall, I think, a year after the elections, and also 2 years to the other general election. So you have 2 years in between, and you have to go to the High Court, file a petition, which must be heard and determined within the court calendar. And then you now lodge another petition with the IBC to process your recall. So you all know that Parliament subsequently enacted under the County Governments Act fresh provisions for recall of members of County Assembly, but did not enact legislation to provide for recall of members of Parliament. So we are seeking to propose that let those provisions that they enacted for recall of members of their county assembly apply to also them. Because if they enacted for the county assemblies, then it means it is good law and should also apply to Parliament. We are also seeking to propose amendments on result transmission. And I heard my brother Felix and other speakers speak ably on that issue. Transmission of results was at the core of nullification of the presidential election of 2017, and we are alive to that. Part of it is for reasons beyond us. For instance, the absence of network coverage in 11,155 polling stations. And two, what was pointed out about our advocates in the Supreme Court being unable to explain what was appearing on the screen that they refer to as statistics, and what is contained in the statutory result declaration forms. And the Supreme Court was clear that results is what is contained in the physical form, the A series, 34As for presidential election. That is the statutory result declaration form that is filled by the presiding officer at the polling station and witnessed by the agents. So in our proposed amendment, we are making it simple because the Constitution requires IBC to put in place a very simple and verifiable voting system, which also includes transmission. So we are making it simple by providing for the image of the statutory result form to be taken and sent directly to the returning officer in charge of the presidential election. Then the requirement for verification will come in when he receives the physical forms, because the Supreme Court decreed that he must receive and verify the physical form 34As. That's for purposes of 2022 general election, about 50,000 plus forms that he will have to go through. Of course, if there are errors, he cannot amend, he cannot correct. All he needs to do is to announce that these are the errors and leave it now to the Supreme Court to determine if a petition is lodged. I want to speak to the issue of dispute resolution that Felix talked about. And thank you. IBC has tried quite well on dispute resolution, and that is pre-election dispute resolution. There is the Electoral Code of Conduct Enforcement Committee that is in place, and this is a statutory committee under the Elections Act with a very clear mandate to ensure that elections is conducted in an environment that is peaceful and that is devoid of violence, that is devoid of intimidation and any reprisals whatsoever. So without blowing the IBC whistle, or what do you say, blowing? Trumpet, yes. In 2017, there was a good attempt by IBC to rein in on politicians who were in breach of the Electoral Code of Conduct. And the Commission did not spare even the big fish. We summoned governors and fined them fines in the region of 1 million, 2 million, and they paid, because the other provision was in the event you default in paying the fine, you would stand disqualified. So that was 71 cases that were had. We had 37 convictions, in quotes, or those that we found culpable. We intend to move a notch higher to ensure that there is no violence, there is no intimidation, particularly the female candidates. so that we have our campaigns conducted within an environment that is conducive for all the candidates and that is free and fair. We have the IBC Nomination Dispute Resolution Committee. That is, again, a statutory committee. And as earlier on mentioned, we entered into an MOU with the Political Parties Disputes Tribunal in the year 2017 that PPDT would handle disputes arising from political party primaries, and IBC would handle disputes arising from registration of candidates. And that worked very well. Of course, PPDT had 300 and over cases. IBC, we had 350. Our cases were limited to the decision of the returning officer of either accepting a candidate as a candidate and registering him, or declining to register him as a candidate. So through a collaborative effort with the judiciary, we had those cases at the Milimani Law Courts and we discharged our mandate quite well. The limitation was in terms of time, and that is one aspect of our plea for reforms in the Elections Amendment Bill 2021, so that the period within which we will be hearing those cases is enlarged from the 10 to probably 14, 15, because we had 350 cases in a record 10 days with no sleep at all. So you can imagine the exhaustion. We also have the Leadership and Integrity Vetting Committee. This was an attempt by IBC in 2017 to enforce the provisions of Chapter 6 of the Constitution. We received a total of 106 cases from the Ethics and Anti-Corruption Commission that the Ethics and Anti-Corruption Commission said did not deserve to be cleared as candidates. So we looked at that record and only managed to disqualify 2 persons. One of them had been convicted in a court of law in Mombasa, somebody by the name Chitavi, for abuse of office. He was previously a public officer. And another one had been, his degree had been declared by the High Court as fake. That is Nyeri, gubernatorial candidate. I think it was Dr. Thuo Madenge. The rest we could not disqualify because of the constitutional provisions. These were people under investigation by the EACC. Some had active cases in court, and you know the constitutional presumption of innocence. And even after conviction, the Constitution still gives a convict an opportunity to exhaust all the available appeal mechanisms. So it was a tall order trying to enforce Chapter 6, and I know it is still going to be a tall order trying to enforce the provisions of Chapter 6 on Leadership and Integrity Act. But you can see the attempt by IBC first in setting up a committee to deliberate that. And this time around, we have engaged EACC in good time and said, let us talk, let us see what we can do so that we can enforce this provision. We only had a setback 3 months ago in respect of a by-election that is being held today, the Kiagu Ward by-election in Meru, because the Leadership and Integrity Vetting Committee, of which I'm the secretary, disqualified a candidate. But that candidate went to the High Court and challenged the decision of that committee. We disqualified him because by the time he presented himself as a candidate, he was still in office as a public officer, an employee of the County Assembly. What did the High Court say? The High Court said that IBC has no business enforcing Chapter 6 and enforcing the Leadership and Integrity Act. That is the preserve of EACC. So that is a judgment of the High Court. We have appealed that judgment in the Court of Appeal, and we hope the Court of Appeal will see some sense and laud us for being proactive in that manner. On communication, I must admit, we have not done quite well on strategic communication. But there is now an attempt to revamp the IBC Communication Docket so that information on elections is shared timely to the stakeholders. Lots of things bound to happen when you have information and you do not disclose it to the stakeholders. Of course, they will go to court, as earlier on mentioned by a presenter here. Now, on capacity building, we have undertaken we have made a deliberate attempt to build the capacity of IBC staff, those that are permanent. But there is a problem in building the capacity of temporary staff. One is because of budgetary constraints. You cannot engage them several months to the polls. You have to engage them just a few weeks to the polls. And that is why some complaints may be made that some of those temporary election officials are wanting in terms of capacity to deliver elections. And this is crucial, of course, because of the judgment of the Court of Appeal in the minor KIA case that elections conducted at the polling station are final. So it's quite a danger. On the 2/3 gender rule, we are alive to the Katiba Institute case, number 19 of 2017, that held that IBC has power to regulate the process by which political parties nominate their candidates. And also the holding that that political parties must put in place within 6 months of delivery of that judgment mechanisms to ensure that the 2/3 gender rule is adhered to, failing in which IBC should develop administrative mechanism to enforce that constitutional requirement. Indeed, we developed, and that is how we required political parties to submit nomination rules by 18th of October, nomination rules that are compliant with the Constitution. And you recall in the first review, after the first review, we rejected all the nomination rules from all the political parties for want of compliance with that provision. And of course, there was the other one of lack of provision for a code of conduct and lack of clear structure for internal dispute resolution mechanism. So as at Monday this week, 72 political parties had complied with that requirement, the 2/3 gender rule, in their nomination rules, and 10 did not comply. So we have engaged the 10 with a view to ensuring that they comply. As earlier on mentioned, the 2/3 rule may be in the political parties' nomination rules. But political parties can also be smart. So in that list, they will put names of ladies or women who they know are unlikely to win their seats. So the list that will be brought to IBC will be compliant. If you look at the list, you will find that not more than one gender is more than 2/3. But when it comes to the actual election, it's another story altogether. But for purposes of complying with the Katiba Institute case, so far we have tried our best, and we undertake to enforce that when the party primaries come. On collaboration, yes, and on the issue of withdrawal from the multi-sector group, I think the commission chairperson addressed it quite well. The perception in the mind of some people who are supporters of the multi-sector working group is that IBC does not want to collaborate with any person. That is not true. Already IBC is collaborating with the National Police Service. IBC is collaborating with the Office of the Director of Public Prosecution. IBC is collaborating with the Independent Police Oversight Authority on Election Security Arrangement Program. And IBC is going to develop what is called the ESAP, Election Security Arrangement Program Hub at Anniversary Towers, where all reports on insecurity will be received and processed and escalated to the duty bearers. So that is a deliberate effort by IBC to collaborate with line agencies. What IBC is reluctant to brook is to cede its independence, because that is provided for in the Constitution. There are challenges moving forward that the Commission has experienced and will continue to experience. And one of them is on profiling of IBC staff ahead of the elections. You are all alive to the letter from NASA in 2017, the reducible minimum, which bore names of staff of IBC that NASA did not want to participate or to be involved in the organization of the election. You are also aware of the Jubilee letter that had names. I was in the Jubilee letter, Crispin Owie, and it was quite unfortunate then, because you know when those letters are issued, when you Google Crispin Owie, the first thing that pops up is the letter of objection from Jubilee Party, and you are at pains to explain to people whether you are impartial or not. So that profiling, and we urge our stakeholders, like the civil society, to help. One, it reduces morale. It stigmatizes. And you know, we were being profiled at a time we had lost one of us. It was in the mortuary. So it's so hard, because we are human. It's hard to have a clear and focused mind when you are distracted by profiling or through profiling. The other problem is security, and because I'm in ESAP, and I also head the investigation and prosecution docket at Ibc, I want to believe that what we have witnessed on insecurity during elections are isolated incidents, and that the same will not be witnessed in the 2022 general election. I was in Juja, and the tallying center was a hall such as this at Mangu High School, well guarded by police officers, GSU, elite squad at the gate, screening everyone. And the returning officer was somewhere there on his desk, and we were seated the other side. And round the auditorium such as this, we had policemen. And on that alley, policemen on this side seated, and policemen on that side seated. Actually, the number of policemen in that hall was about a third of those present. And a Kenyan walks from that door, making a lot of noise, protesting, and goes down the stairs, passing policemen, and moves up to where the returning officer is, gets hold of a lamp, and attempts to hit the returning officer with the lamp. And policemen are watching. Kiambaa incident, almost a similar scenario. We have policemen seated in the tallying center, and we have a gentleman and a lady. Only two people pushing the tables, overturning the tables, and advancing towards the returning officer. And they cannot be arrested. It is only the police officers who are attached to Anniversary Towers, IBC, that managed to restrain these two people. And if you ask them later, these policemen, they say, hao ni wakubwa. That can only mean that they were probably senior police officers that could not be arrested by police officers of a lower rank. So you need to be very vigilant, and chairman has spoken, the chairman of IBC has spoken to this, and we have had a meeting with the Inspector General on this security concern. The Inspector General committed that there will be no repeat of this. But you need to be on the lookout to call out on institutions that fail in their constitutional mandate. Under Section 105 of the Elections Act, the state organs are under duty to cooperate with the IEBC to ensure that there is efficient management of elections and that there is delivery of good elections, secure elections. So that is why under that section, police officers who have been engaged to provide security are recognized by the law as election officials. So a police officer at the polling station is under the presiding officer. So those are the serious discussions that we are having. On technology, and I'm about to wind up.
I'm loath to harass you, but you're winding up.
Yes, I'm winding up.
Okay,
It's quite long. This is a topic I can take about 2 or 3 hours about. On technology, the Commission has reviewed its election result transmission framework, just to ensure that it is simple, to ensure that it is secure, and to ensure that it is accountable. And the Commission has said that it will issue all stakeholders, including the media, with servers to access those results, and will engage the media and encourage the media to be present in at least, if not possible, a cross-section of the polling stations to report the results, because the results are there. That is where the results are, and you don't need to even go to the tallying center if you obtain those results. Colleagues, that is all. Diaspora, Dr. has mentioned, we are doing mapping currently, and we intend to go to UK, Germany, Canada, and in the US there are 3 polling stations earmarked, Washington, DC, New York, and Los Angeles. So we are trying to heed the Supreme Court, advisory opinion, and also the Constitution and the Elections Act on progressive realization of the right to vote for Kenyans who are living outside this country, who are popularly known as diaspora. Thank you. That's all.
Thank you. Makofi. You know, he was responding to a lot of speakers and a lot of issues raised. And as he mentioned, it's hard to be IEBC, but we believe you are up to the task, and that's why we're also so hard on you. But it's important to remember that it is people in the office. I think I'm now concluding the session, but before I wrap up, Carol, you had an announcement?
Thanks, Regina, for the indulgence. When I made my statements, I did make a commitment to ensure that everybody, we keep participants aware of the legislative calendar, and in line with the hour on Parliament. As I was seated here, Lois, our communications officer, did bring something to my attention, so that there's an update from Parliament about a special sitting next week, and I wanted to just highlight the bills that they'll be considering because they are relevant to this meeting. So there'll be a special sitting on 21st and 22nd. And for consideration that's of concern, of course, is there'll be the first reading of the Huduma Bill, the National Assembly Bill number 57 of 2021. But what I thought was important is the bill, some of the bills I had highlighted here, the Political Parties Amendment Bill, that's a National Assembly Bill number 56, the one I spoke about, coalitions, funding, and removal from the party. This we go through the second and the third reading, and the second, the Committee of the Whole House, and third reading on the next week. And also in terms of the leadership and integrity, the Proceeds of Crime and Anti-Money Laundering Amendment Bill, which will also go through the entire process up to the third reading. I thought that was important as we had the conversation. There are a couple of others, including the consideration of appointees to the National Gender and Equality Commission. So just to keep an eye, and we'll share this on our platforms. Thank you.
And a good note to end on that we need to be eternally vigilant and to participate and to be active and proactive. Ladies and gentlemen, thank you for your attention this afternoon. It's been a very long panel, but we've had very rich and exciting inputs and challenges and things that we must address. I think what comes out very clearly for me is that you need an enabling environment to get the elections that we want and we deserve as Kenyans. And key to getting this enabling environment is the protection of the electoral process, the people wherever they are in the process and the cycle, our data, our rights, and even our representation, so that we ensure that we are inclusive and everybody's voice is heard and everybody's votes count. But in addition to that, you need enabling laws to have an enabling environment. And the systems must be in place, and they must be predictable, well-known and understood, simple and verifiable, to take the words of our previous speaker, even when it comes to complicated issues such as dispute resolution. But they also must be carried by the people, whether it is through the courts in public interest litigation, whether it is at the ballot, whether it is online or offline. And therefore, we've had very rich conversation from the morning till now. And the question I've asked myself, and I think we discussed it over lunch with Domi, was how do we package all this information to make it accessible, especially for that age group we've identified since morning, the 18 to 24, but even younger than that, because we're going to talk about people that we're starting to build as civic actors. So the age of 10 to 18 and maybe even younger. How do we package the conversations that have been had here in a palatable form? Because we've also used acronyms that only we ourselves know. So when you talk about PPDT, do my nieces and nephews who are in that age group of 18 to 24 understand what we are talking about? And how do you make that simple? Does my grandmother in the village understand that? And how do you make that simple? So kazi kwa uraia in helping us package this information for the masses. And then finally, ELOG and the Technical Working Group on Elections had also identified a matrix of issues from the last election and have been tracking those as electoral reforms agenda. And I hope that that is online and it is simple and we can actually start to tick off some of the things that have been done, and those that have not been done, we start to raise a flag and maybe have it in a visual representation that actually appeals to the younger audience or to the more tech-savvy audience. Ladies and gentlemen, we have 236 days. Let's make it count. Thank you. Makofi for the awesome panel that we've had. And I'll now hand over to Marcus to take us through the next session. Thank you.
Thank you very much, Regina, and thank you, the team that has taken us through that session. Indeed, it was a very long session. But I want to invite ourselves to bear with us. We are almost getting done for the day. So this takes us to the next session. And as we did with the just ending session, we would like to combine two thematic areas. And these areas will be focusing on accountability, leadership, and integrity in elective office, as well as political party processes and inclusion aspect of this thematic area on special interest groups. So I would like to invite in this panel the following organizations and their representatives. I would like to invite Lucas from the Kenya National Commission on Human Rights to come and join to come forward. I would like to invite Dr. Makanda from the Evangelical Alliance of Kenya. Please, Daktari, you come forward to help us disclose some of these issues. I would like to invite Kennedy Masime, who is the Executive Director for Center for Governance and Democracy and a member of ELOG Steering Committee. I would like to invite Nyang'ori, who is also the Executive Director for Center for Minority Rights and Development. He was also a member of ELOG. And also invite Range, who is the program head at CMD Kenya. Welcome. I would also like to invite, I know she had spoken earlier on, but I would like to invite Sheila. Of course, when we speak about integrity and accountability and leadership, TA has been at the forefront. So Sheila, please come and join the team so that we can start the discussions. Thank you, Sheila, for joining the team. Now, I think to start us off in this discussion, I would like to invite Lucas from the Kenya National Commission on Human Rights, who is also a partner in this forum, to just take a few minutes to help us identify some of the critical issues. Of course, I know that in the morning session, the CEO spoke to some of them, but just highlighting some of the critical issues around leadership and around human rights, especially the human rights approach. We know, for instance, that election and political rights are part of human rights, and we know that for every right, there is a corresponding duty. And as you sit in that commission, as a commission, what are some of the critical issues that you think are important, and how these issues must be taken up to ensure that the elections that are coming up are truly a celebration of human rights? Karibu, Lucas.
Allow me to remove this. Good afternoon. As you've heard, my name is Lucas Kimanthi. I serve at the Kenya National Commission on Human Rights. I just want to begin by highlighting two key issues as to the reason why, as the Kenya National Commission on Human Rights, and by extension, as actors who have gathered in this auditorium, why we must always demand for accountability in terms of, electoral processes, and also demand for integrity on the same. The first thing is that elections, and as Marcus has alluded to, is a subset, within the human rights spectrum. There is a right to participate in electoral processes. And on top of that, why, as the Kenya National Commission on Human Rights and as actors keep on demanding for accountability and integrity, is that the end product of electoral processes gives us leaders, lawmakers, who decide the kind of laws, resource allocation in terms of public finances, which have a direct bearing on the enjoyment of human rights. I would want to say that as the Kenya National Commission on Human Rights, since 2005, we've been running projects at any given electoral cycle to monitor elections, and for us, we do the very active monitoring in terms of looking at all the particular human rights issues within the electoral process. 2005 for the then referendum, 2007, 2013, and recently 2017 and 2018. A number of issues that as a commission and as Kenyans we must be concerned about is the issue of the basic rights and also the fundamental rights for Kenyans. And for us as a commission, we are concerned about the rights of the citizens as voters, and also the rights of the aspirants and the candidates who present themselves in the electoral process. A number of things. One, as a commission, we really get concerned that the very important right, the right to life, that, and if I can quote our statistics from our 2017 reports, that we lost 99 people as a result of the electoral process. And sadly, out of the 99, 10 were children who had nothing to do with the elections, whether as voters or aspirants or candidates. But unfortunately, they lost their lives. Other things, things to do with, displacements, destruction of private and public property, misuse of public resources and all that. And for us, one of the things that concern us in terms of the misuse of public resources is that when you're in a position, either a government position and you're holding a public office, and you are able to use probably your office car, your driver, your bodyguard, your assistants, to help you in the campaigns, and you are contesting against somebody who does not have, that provision, then of course you disadvantage your opponent, and that's wrong. In terms of displacement of persons, intimidation that certain sections, either politicians or citizens, would want to harass other sections of communities and tell them that if you don't support our ideology, if you don't support our candidate, then you either move out of our region. At that point, it becomes our region, or as they say, you face the music. Issues to do with brutality and use of excessive force, and I'll say something later on about that. As a country, whenever we're having elections, during the campaigns, polling process, and even after the announcement of results, that there's a serious problem in terms of excessive use of force by security personnel and also other government, departments. And then, this at times, would scare people from exercising that right to participate in the elections, whether as voters or as candidates. And that also is linked to the issues of, torture and related issues. And then lastly, as I conclude on that particular bit, that for us as a commission, in our protection mandate, that for us we are very clear that our major concern is the right of a Kenyan to participate in the electoral process, so that for us we take, would I call it an offense, whereby any qualified, registered voter is denied that right to participate. Two, we also take offense, quote unquote, where we get reports that a certain aspirant, a certain candidate has been denied, the right to participate in the elections. What internally we call the right to vote and the right to be voted for. A few recommendations, allow me to make just a few that as a commission we'd want to make moving forward ahead of the 2022 general elections. My brother from Ibc, spoke about the issue of clearance of candidates. And internally as a commission, we've raised a number of issues. And we've given, the analogy of, for instance, when a young person leaves university or other institutions of higher learning, and to qualify for a public or a government job, you have to go, I don't know, to how many government agencies, get a police clearance, ESCC has to clear you, and many, many other organizations. And therefore, if we put such high premium for a young person who has just left the university or any other higher institution of learning, why is it that when it comes to the aspirants and the candidates, we lower the bar? Why is it that as much as I know IBC, you've said you're trying, in 2017 you tried, but in the eyes of Kenyans, we are very much sure that there are people who have been cleared to contest in the elections, yet they don't deserve. In 2017, I know there was the Chapter 6 working group, and as a commission, one of the things that we requested, at that point we were not demanding, is to be included in that working group, because issues of corruption, issues of all those other listed things, we said we also want to clear candidates who have clean track record in terms of human rights. That if a candidate is somebody who has a bad track record in terms of violation of human rights, incitement, funding militia and such, then we also wanted to come in, from that perspective. And our strength is, as a commission, is of course we do heavy monitoring, we document, and we have the evidence. And therefore for us, we'd want to see more. We'd want to support IBC and all those other institutions our database has enough information so that next time ahead of 2022, when you're clearing preparations on 1, 2, 3 points, we feel as Kenyans, we feel as agencies that we are not adequately prepared. The best thing is to engage positively, okay? And I want to say that I've looked at the elections operations plan, which my brother from Ibc has alluded to. It's a good document. It's a good advocacy document which we can partner so that we stop also appearing like we are pulling from opposite sides, and also help you implement that important document, which in my own opinion was properly done. The second recommendation as a commission that we want to make is, of course, the issue of enforcement of the rule of law, especially on 3 key agencies here, the ORPP, IBC, and NCAC. When a warning is given on a matter that is a clear breach of the rule of law, for us, we feel IBC at that point is not doing what it's supposed to be doing. For instance, when we talk of early campaigns and we say candidates, aspirants are campaigning when the gazettement of the date has not been done. So we're supposed to enforce that. If it is not within your mandate, who is your partner, who is the other stakeholder who can enforce that? Those are the things that we want to hear. The law is very clear. For instance, on issues of if you belong to a certain political party and you sit in the county assembly, the Senate, or the National Assembly, and you seem openly to be promoting the ideals of another political party, openly, with evidence, public announcements that I'm no longer supporting this political party, I've already shifted to the next political party. Who is supposed to take action on such issues? If it is not within your duty, within your mandate, then perhaps you can approach other stakeholders who are here and who can help on such. The other thing that we would want to recommend as a commission, that already the actors who have observed elections, ELOG, KHRC, IMBLU, and many, many other organizations, and also ourselves as the Kenya National Commission on Human Rights, we've made many, many recommendations starting from 2005 and recently 2017, 2018. For us, what we've done as a commission is we've compiled all the recommendations to the relevant actors and we've put them in one document. And therefore, for us, as we prepare for 2022, we might not need to look so far because already ELOG, KHRC, and other institutions have already documented and they've given recommendations. We can have a look at some of them. Tied to that, there's need also to act on the complaints that have been raised in the past electoral processes. In the documented scenarios from various institutions. For instance, the issue of SGBV, the matter of the 2007 case, still not yet properly concluded. As a commission, we documented 201 cases of sexual and gender-based violence directly relating to the 2017-2018 elections. That is quite too many. And therefore, for us, if action is not going to be taken against the perpetrators before 2022, because it started in 2007 or even earlier, what it means, this trend of impunity will stretch to 2022, God forbid. Therefore, there's need to take judicial action. Those who have been implicated, the perpetrators, need to be taken to account. The other thing is for the political parties. CMD, I know you are doing some very good work with the political parties. But you recall that in 2017, our first report on elections monitoring was about the party primaries, which we titled fallacious votes, and for a reason. That a fallacy is something that, would be said to be there, but not yet there. In terms of preparations, in terms of how the primaries were conducted, we went around the country in our targeted regions. And, what we saw there for us, the only thing that we could conclude was that the whole exercise for the political parties, it was just a fallacy. And the worst thing that we noticed, which also enabled us to conclude, to have that title, was the issue of the register of party members. The speaker from ORPP earlier today said that they are the custodians of all the registers of political party members. But we noticed, allow me just to give one scenario, somewhere in a county, in Bomet County. Went there, and they had booked a classroom, a room like this. And the political party, just like when we came in the morning, would register and get into this auditorium. So citizens would come, register, and automatically become members of that political party, get into the classroom and vote, participate in the party primaries. Therefore, when we see such things happening, then it's not the right thing to do. CMD kindly and other partners, we need really to support political parties. But even before that, the political parties themselves need to put their house in order, adhere to the rule of law and all other policies. Then I talked about use of excessive force, and we know security is a critical element in elections. But when it is excessively done, then either it will scare people, or people will get a chance, to give funny excuses that I lost because my people were turned away by security agencies. So to conclude, I just want to say that for us as KNCHR, we've already put together our elections monitoring project. It's up and running. Yesterday, we launched our strategy. I know some of the partners in this room attended. And we are going to monitor 4 phases, starting from the preparations. Secondly, party primaries. Third, we'll monitor the campaigns, the polling process, and the transmission of results. And then lastly, we'll be looking at the post-election period. Then lastly, that in the strategy that we launched yesterday, which is going to give us directions, a commission, ahead of the 2022 elections, that we also are going to be very keen on the issue of vulnerable and minority groups. These are intersex persons. For the first time in this country, there will be that sex marker. And then the other group also very critical. And I was keen to hear since morning whether I would mention this, the issue of prisoners. They're also going to be voting. And then we'll also look at issues of youth, women, and other people who have physical challenges. And for us as a commission to implement the strategy which we launched yesterday, definitely would want partnerships, would want to work with as many stakeholders as possible. Allow me to stop at this point. Thank you very much.
Thanks, Lucas, from the Kenya National Commission on Human Rights. Next in line is we are being joined virtually by someone from the Office of the Registrar of Political Parties. Of course, during these discussions, a lot has been said about the Office of the Registrar of Political Parties, and especially on political parties. But as she comes, she's called Gadoni, and perhaps she can limit herself, if it's possible, Gadoni, to focus on the party membership list. Of course, in the previous elections, one of the issues that, as observers, we have identified is the use of names and lists drawn from the IBC. While we know that the law requires parties to have their own lists of members, and that should be the one they use when conducting their party primaries. So as you come in to give your remarks, maybe you can focus on that area, but also what is your office doing, especially as we have identified party primaries as a major problem. So what are you doing exactly to help bring order and sanity to that process? Welcome, Gadoni, if you can hear me.
Thank you very much. Thank you for the opportunity. And the office of, I represent the Office of the Registrar of Political Parties. Can you be able to hear me?
Yeah, we can hear you very well, Gadoni. Please proceed.
Oh, Sarah Cyprius. So the Office of the Registrar, maybe I should start on what we've done so far in terms of preparedness for the 2022 general election. And one thing that we've been really keen on is the use of technology, and I've had other speakers really go on it. We have enabled the use of uploaded our services on the eCitizen platform, and we've allowed, or it's now enabling members of the public and members of the political parties to be able to check their membership status, to be able to freely resign, and to be able to even register as members to other political parties. Similarly, we also have issues regarding now development of policies, manuals that will aid in the coming elections. And these manuals are speaking to issues regarding the coalitions, issues of mergers. And these are things that we will see coming up. And the Political Parties Amendment Bill, which was spoken of previously under the legal reform process that will be tabled by the National Assembly for discussion. And that one, part of the things that we are proposing in that bill is the issues regarding now the party primaries, what you are alluding to, what you're talking about. So the party primaries, or what we are proposing is for the political parties or Office of the Registrar of Political Parties to oversee the process of the primaries or the nominations, the party nominations. And this will ensure that even the register or the membership list that is being used is a certified list. And one of the proposals is to have at least a 21-day period, given it a timeline where political parties are required to ensure that they have already submitted their membership list for certification to the Office of the Registrar of Political Parties, such that now on the nomination days, then we'll be sure, or it's guaranteed, that whatever list the parties are using has been confirmed and verified that it's the list of the members of the political parties, and those are the only people who are required to participate in the nomination process within the political party. The amendment bill, as I had mentioned earlier, it's also looking into issues of mergers and coalitions, again, which we are really keen about. And now we are seeing that we are proposing that political parties should be able to maybe register a coalition in terms of it being, say, a political party. It's a registration of a coalition rather than what we used to have multiple political parties being able to form coalitions with multiple other political parties, for lack of a better word. So it means that a political party can only be in one coalition at a go. And that is a good development, and it will aid in so many things that we are seeing currently or ongoing. The other issues that we have done within the office is we have a standing committee that is between ourselves and the commission, that is the IBC. And this standing committee, we have so far reviewed the nomination rules, which my colleague from IBC spoke about, and the parties have been well guided, and so far 72 parties are compliant, which is a good turnout. The other issue is with regards to that the committee intends to provide technical assistance on various processes, including now the issue of membership party lists, nominations, and the nominations with regards to the commission, or what the commission does, or calls the party nominations. In this particular process, we see that the Office of the Registrar of Political Parties assists or comes in strongly to just verify the membership statuses of the people who will be nominated or have been nominated in these party lists, or the candidates or aspirants who are intending to be nominated by IEBC for purposes of participating in the elections. We've also worked with in terms of representations, we've so far worked with special interest groups such as women, youth at the regional level, and persons with disability. We've held engagements with them for purposes of capacity building. We've also sensitized them, especially the ones who are aspiring to vie in the coming elections. So as an office, we feel like we are ready, we are prepared, and we are taking the necessary steps and putting in place necessary steps to ensure that next year we have more or less satisfied candidates or aspirants, and we've, based on the lessons that we have learned in the previous election and the coming election, we are applying those lessons to be able to ensure that we create a fair playing field for the aspirants. Thank you very much.
From our seats, if coming here would be too much to ask, but we could just pick from there. But Rangi, you work very closely as an institution with the political parties and especially their leaders. And it's been said several times about the party primaries and apparent shambolic nature. I say apparent because parties sometimes deny them, but from observers' point of view, they are not done very well. There are questions about lack of comprehensive inter and intra-party democracy within the parties. And of course, the so-called capture of some of the mechanisms and structures within the parties to resolve disputes. So I would like you, from the CMD point of view, what are some of your thoughts around those areas? And as you speak, when Kennedy Masime, the same questions that we are addressing ourselves to in terms of what must be done differently about political party primaries in terms of enhancing and promoting party democracy within and outside the parties. And of course, Bwana Masime, you may address yourself particularly about single independent, the emergence of independent candidates, and whether that is going to be a threat to the future party primaries moving forward. So, Banarange, please proceed.
Thank you. Thank you so much, Marcus. I want to be brief, very brief. I work with the Center for Multi-Party Democracy, that is CMD Kenya, and we are a membership organization of political parties that we support parties in terms of ensuring that there is sufficient space for cross-party dialogue and also intra-party dialogue to ensure that conflict does not really spill over from one party to the other. They can have a space where they can come together to have some dialogue. We have also been supporting political parties to strengthen their conflict transformation mechanisms, that is IDRM, ensure that challenges that arise, especially from the party primaries, are able to be solved within the political party, are not necessarily being translated or transformed into the judiciary, that is PPDT, for purposes of solution. We also support parties around the inclusion of marginalized groups, that is the young people, the youth, the PWDs, and the women, ensure that political parties have systems that they can use to ensure that these groups have some level of representation especially around elections and also during party primaries. And also to ensure that the political parties are internally democratic in line with what the Constitution provides for around the marginalized groups being able to be represented during the party primaries and also during elections. We have been running programs around strengthening the internal mechanisms of the political parties to conduct the party primaries. I know this is a big problem, the elephant in the room, on how the party primaries can be conducted in a way that the conflicts that arise there do not spill over to the general elections. But even then, we appreciate the challenges that CMD has noted, looking at the past and going forward. While political parties have been evolving slowly to strengthen the internal mechanisms to run their programs and conduct their activities, there's a challenge that we must appreciate, that going to the 2022 elections, there's a challenge around, there's a context under which the elections are being held in this country, and it remains. We thought that the proposed party primaries bill 2020 was going to streamline the conduct of the party primaries in April 2022. But as we are today, we must appreciate that the bill has not gone through and is not likely to go through before we go to the next elections. That's the reality we must appreciate. So it means that we're going to approach the 2022 elections in the same context that we were in 2013 and 2017 elections. What does that mean? That we are likely to face the money clout in our electoral processes. That money will play a very big role in determining and shaping how the political parties and politicians behave during the party primaries and also during the elections. Ibc did say in the morning, and also our colleague Crispin said, that if the money is not regulated before the elections, then it means the person with the highest pocket or purse is likely to win during the party primaries and also during the elections. So what does that mean? We are likely to have a lot of violence during the party, the electoral process throughout. Political parties have not also embraced the democratic ideals that are there in the Constitution. The right to participation of the marginalized groups. It is there on paper, and I know all political parties have really submitted the nomination rules to IBC, but we need to question ourselves. If they have not been embraced in the previous elections, and we're going to approach the 2022 elections in the same context, what does that mean? It means that the right to political participation is likely to be compromised, especially by the political parties, because also of the aspect of money and also nepotism. There's an aspect of party ownership. Political parties are not ideologically aligned. We must appreciate that. They are owned somehow by individuals. If that is the reality we are in, what will the 2022 election mean if the political parties are going to not to give candidates that qualify to vie for political offices, but give people who are loyal to them as opposed to the issues that the party really stands for? So what that portends when we head to the 2022 elections, and especially the party primaries I want to speak to, is that we are going to have we have currently around 80 plus political parties that are going to contest for elections. It means that even the institutions that are going to deal with the issue of disputes will have enough clients to deal with. That is PPDT. The question we need to ask ourselves is PPDT properly capacitated to deal with 89 political parties, and each party bring the issues to deal with conflicts? We are talking about the lack of organizational acumen on the part of the political parties. Political parties do not have membership registers. So when we go to the party primaries to pick the candidates to contest for elections, to contest there, and you don't have a membership register, who is going to be your member? Lucas Kimanthi did talk about that they did realize in 2017, and we are approaching 2022 in the same context at 2017, that political parties could register members at the same point, right, when they are going to pick their candidates. So somebody shows up, somebody can come to one party A and become a member here, go to party B, become a member there, party C, become a member there, and pick a candidate who is going to win the party primaries level. So what does that entail? That our democratic democracy is going to be compromised at the level of the party primaries. Political parties do not have finances. Only 2 parties are being funded by the PPF. What about the 87 or so parties that need to put enough infrastructure across the country to be able to run credible party primaries? It is a challenge. It requires resources, and if political parties do not have resources, then what we are likely to see is that political parties are going to resort to selling the nomination certificates at the expense of conducting party primaries that are credible and acceptable to their members. The lack of sufficient voting materials is a challenge to the parties. It will be there. If parties do not have money, it means that they will not be able to even print enough voting materials during the party primaries for them to be able to conduct good party elections. There are weak internal dispute resolution mechanisms within the parties. Most of these dispute resolution mechanisms are at the national level in Nairobi. What if somebody is aggrieved in Turkana and he has to come to Nairobi to seek justice, and the duration for seeking that justice is actually less than 20 days? We have the problems of COVID-19. There could be restrictions of transport traveling from the other areas to Nairobi to seek this particular justice. What will happen? And do the parties have the capacity to deal with these issues of that are rising from the party primaries? That is a challenge that we need to look at and see how we can deal with it. Political parties, I talked about the party registers. We've realized that most political parties have more supporters and not members. So these supporters, if they are not members and they do not understand the mechanism of becoming members, and therefore it means they don't understand the nomination rules of the party, it means that they are likely to undermine the party nomination process, which is very critical for this process. I talked about the money clout in politics. If money is going to play a critical role in this process and political parties do not have money for campaigns, it means that the highest bidder is likely to be granted the certificate at the expense of the people who really mean well or understand the party well. Another issue that we have realized as a CMD, another challenge, is the elite capture of political parties. The parties are owned by individuals. They are mostly in business and sometimes not really into politics. So what does that mean? There's likely to be deliberate sabotage of the party owners on the candidates that really deserve the party certificates. How do we deal with that problem? Because on the day of nomination, we have realized that political parties sometimes open very late. At 3 p.m., voting materials have not arrived at the polling station, and they close at 5. So what does that mean to the candidates that really mean well? And also the aspect of voter movement. If we don't look at how to streamline the party nomination process and also regulate it, then it means that there is a porous position that politicians will move voters from one constituency or from one location to the other and back to vote for their favorite candidates because they are being given some amount of money because of the money, the aspect of money in politics. Then finally, our electoral environment is basically very toxic. It is tribal, and political parties face challenges of infiltration from other political parties. It is a way of ensuring that one party infiltrates another party's a stronghold to nominate a weak candidate so that there is a possibility that a weak candidate will be presented at the ballot to give an opportunity to the competing political party to win. That is a challenge that must be looked into, and also the aspect of mushrooming political parties. So many new parties are coming up. 2 days ago, DAPK was launched in Western Kenya. How sure are we that in 2022, April, DAPK will have the machinery and the structures to conduct credible party nominations? Is a challenge that is going to face us. So as a way forward, we propose that political parties need to have very credible membership registers that will be used during the party primaries, so that the members of the party are the ones that are allowed to vote at the level of the party primaries. And number two, political parties must have proper disciplinary mechanisms so that they can deal with members who are actually violent or influencing other members to vote in a particular way that is not in line with the law or the party's mechanisms. Number three, political parties to hold the primaries early on time. The commissioner who spoke here from Ibc earlier told us that they have allowed political parties to have the primaries from 19th of January to the time when the law allows. We must encourage parties to hold the primaries as early as possible so that they can have time to deal with internal disputes before being taken to the judiciary for consideration. Finally, parties should deploy and train their election personnel early on time so that they understand the voting process, who is voting, they have the register and the voting materials, so that to deal with the issues of disputed elections during the party primaries. Thank you so much.
Thank you, Range, and for those wonderful insights from CMD Kenya. Now, I would like to request that you bear with us. We are almost coming to the end, so just stay put. So as we continue the conversations, of course, the issue about political parties is a central issue, and we know that we are a multi-party democracy. And so, like I said earlier on, Kennedy Masime, who is the Executive Director for Center for Governance and Democracy, CGD has worked for so long and has enough experience in this sector. So, Bwana Kennedy, they say that independent candidates is God sent. And part of the reasons they are telling us is that, well, parties have their owners, the processes are not credible enough. Do you see the rise in this in independent candidature, and whether that is a threat to our multi-party democracy and as a death sentence to and as a protest to party primaries that have been conducted in a shambolic nature?
Thank you very much, Marcus. I'll answer your question, but before I say that, maybe I'll repeat some of the things that Range said, because it will help us make that point better. And I want to begin from where he left, but maybe to a correction. I come from the Center for Governance and Development, not democracy, but it's a mistake a lot of people do. And I suspect maybe the mistakes on our side, we should call ourselves properly. Because people describe what we do, I think it's democracy. But it's Center for Governance and Development. Now, I just want to say that it is sad that as a country, we don't learn lessons, and then we keep on repeating the same mistakes year in, year out. Around 2011, I invited the late Samuel Kivuitu to an ELOG meeting to discuss a topic like this. And my colleagues almost crucified me for that. Because our attitude is that he has failed, so will never be heard again on the surface of this earth, but I think that's where we get it wrong and keep on making the same mistake. If you ask me, apart from the unfortunate incidents that happened last minute in 2007, in terms of qualitatively, the party processes were much better than 2013 and 2017. Of course, this is debatable, but just two incidents will remind you that perhaps this is the case. That's the first time that we had serious party nominations. Remember the nomination of the ODM candidate, where we had a properly organized delegates conference, and there was a fairly serious contest, and someone demanded the winner. The contest between Biwot and Uhuru Kenyatta in Kanu again. It was even monitored by IED, the civil society organization. It was a serious fight, and that's determined the chairman, who was supposed to be the presidential candidate before, that's Uhuru Kenyatta, before he absconded and went to join Kibaki. So we are doing worse than where we were. And if I repeat what he said, where are the political parties? It takes time to build institutions. So you cannot form a political party today and expect it to organize proper party primaries tomorrow. It won't happen. It takes time. So what happened? These parties have no structures on the ground. And for some of us who monitor elections, it is candidates now who organize the elections. You want to become an MP or a governor, you finance the nomination process, including the ballots and everything. So what do we see? Buses or matatus carrying youth who go to vote for the candidates who are, and they are facilitated. This is something you can witness. And I'll relate that to minority participation when those kind of things happen. Then something again that has been repeated along is that the issue of amorphous party membership. We have to differentiate between the selectorate and the electorate. The selectorate are the party members who are supposed to participate in the nomination of the various candidates, presidential or parliamentary. And then the electorate. Now, like Rangi and others have said, we don't differentiate between the two. And then now, the nominations become literally fallacious, like you call them. There's no way you can conduct universal elections during the primaries, and what they attempt to do, with a budget of, I've never heard of a party who can raise even 1 billion for the exercise, versus about 50 billion that's used by Ibc, and they still have challenges. So basically what you are saying is that we don't want to conduct nominations, so we just engage in a process, and that has an implication for independent candidates and of course the participation of the minorities. So the other issue is the capacity of IEBC and ORPP. Of course, today they have spoken like ORP and say they now have built the capacity. We hope it's there. And then non-implementation of the laws. Remember, I'm talking about 207 and better primaries when there was no Constitution of Kenya 2010, and there was no even the Political Parties Act. It had not been operationalized, but we had better. So it's a question of just taking a decision to do the right thing and implementing the few laws that we have. So even as we talk about which law is pending, I don't think that's where the problem is. And then parties add, makes the decision worse by, of course, doing the universal suffrage, but then now tactically, because they don't want the rivals to exploit the situation, so all of them will tactically delay the exercise to the last minute, where it's done even midnight, and they have done it in the last two elections, and it has failed completely across the parties, and they are even to postpone it. And that's something that can be avoided by starting it early. So what I'm saying is that these practices and the situation has a bearing on, to begin with, the participation of minority. Once you create that kind of situation where individual members or candidates facilitate everything, then money becomes an issue. If you don't have money, you cannot fairly participated in those elections. Violence becomes an issue because you've created the stage for it. Sometimes just beating people and scaring them from participating in that exercise will allow someone to win. That's already a motivation. Sometimes that's to do with whoever can afford a chopper to get to the party headquarters to pick the certificate when someone is already still using a bus or his car to get to Nairobi. And then that's how it's decided. By the time you get there, the guy has been given a certificate. So PWDs, women, youth, numerical minorities, they can't cope under such circumstances. And then maybe let me conclude with the issue of independent candidates. Of course, all these overload the dispute resolution mechanism because it's a mess. So they just have to whitewash whatever mess has been done on the other side. Independent candidature is, as a mechanism, I see it as a safety valve to help people who cannot get justice and democracy within the parties. So it should be the exception rather than the rule. If you have independent candidates to the level where we had, was it in 2017, where they held their own national delegate conference, and I think the attendance was 1,700. Assuming you even get 30 independent candidates to get into parliament, how will you govern? We need political parties to transact parliamentary business, and that's how you can govern a country. So it's a safety valve, and it should be the exception rather than the rule. Thank you.
Thank you, Bwana Kennedy, for such insights that have been relayed to us. I would like then to move to the next speakers. The next speakers, of course, the role of elections in terms of not only producing leaders, but also producing good leaders. And perhaps there's a role that the churches can play. There is also the role that civil society organizations can equally play to ensure that the leaders we get are effective and also respond to our needs. In fact, it's always said that show me the one who leads you and I'll show you who you are. So sometimes the leaders that we elect are a reflection of who we are. And of course, part of the discussions we've had, that part of the issues we've had is that even to enforce Chapter 6 of our Constitution is problematic. Of course, the IBC had challenges and of course professed on some of the issues that they have in terms of vetting some of these leaders and such issues. So I would like to invite of course, two people to speak to the topic. And of course, from the religious sector, I would like to invite the General Secretary of Evangelical Alliance of Kenya, Dr. Makanda, to share a few insights on how the churches can help towards helping the country realize good leadership. But of course, then after that, then we'll have Sheila Mathinde, who is the Executive Director of Transparency International, to also speak to that from a civil society angle. Dr. Hari, welcome.
Thank you very much, and good evening. As Marcus has said, my name is Nelson Makanda, working and serving as the General Secretary of the Evangelical Alliance of Kenya. Allow me to start by acknowledging the fact that it's hard to legislate values. And elections, as it were, in this country, is critically a legal process. Values end up taking a backseat in this process. It's a legal process to the extent that in the very constitution that we fought for, and the religious sector has a huge mark on the constitution that we have today. It's a baby born out of critical efforts of the religious sector, the church and our colleagues from other faiths pushed and pushed. Even when the civil society did not exist, the church worked for it to birth the space that we can see today. But then when the constitution was brought, the new constitution, we made a provision, Marcus, and it would be hard even for Kenya National Commission for Human Rights to engage the subject that Kimanzi was engaging here, because we have provided for an appellate process, exhaustion of an appellate process for any criminal convicted or not convicted before we can bar them from running in an election. And as long as that law is in place, we have made it legal for us to go into an election with candidates who we might have vetted and known that they have committed crimes against humanity, they have stolen from public coffers, they have committed offenses that will otherwise not be allowed for any leader in a public office. And so if we do not deal with that place, with that space and that area of legislation and the legalities that have been provided, it does appear that our electoral process has no capacity and ability to present to the electorate candidates who have been vetted and endorsed morally. And it's a space that we must accept. And for us from church, we appreciate that we live in a fallen society. And since we live in a fallen society, it is one of those struggles we have to live alongside with. We would like to do away with it, but until our advocacy and our capacity to lobby and our united voice is able to support the legislation and amendment of that legal provision, we can still live with what we have. But on the other side, all is not lost, because we have people that we can talk to. The people who go to elect are members of our churches, are members of our mosques, they are members of our temples. They are citizens we engage and meet continually. And so we can engage them in a manner to let them know what it is that we are looking for when we go to elect. And at the Evangelical Alliance of Kenya, we have committed ourselves to engage our 50,000 plus congregations across the country by engaging their pastors and engaging their leaders in civic education. We currently run a program that many of them are following on Hope TV called The Leader, just to be able to help them with civic education, but then also to reach out to them to begin to see that if they prepare their members, when their members go to vote, they are voting for a servant of God. Because that's what the Bible talks about leaders that govern us. Paul writes and says that the leader is God's servant for your good. And so if the MCA is God's servant, if the MP is God's servant, if the governor, the senator, the woman rep, and the president are God's servants, then they are my colleagues. Then the same standards that they apply in placing me in office as clergy, same standards must apply, because Scripture in Romans 13, verse 4, calls them thus. They are God's servants. And so we have gone out to engage our members with civic education, and we will do this across the country, to know that when they go to vote, they are voting a servant of God. And what do we require for a servant of God? That's how we would like to see them. And so we will engage our members in that manner. But on the other side, we are also trying to encourage members of good standing, members of faith, Christians, to be able to come out and engage in politics. Because we have been told for a very long time that politics is dirty, and so leave it for the dirty people. We are trying to change that narrative by letting our colleagues, Christians, and those who are not Christians, who are of good standing, to consider these positions of leadership. Because if we do not do that, the county assemblies, the National Assembly, and the Senate will all be filled up by people, men and women, of low caliber in terms of their morality. And we cannot expect heaven from such members. That is the reason why that bill cannot be debated in this parliament. Because if they do, then they have already provided room for their own exit. And so it can never be prioritized. It will not be prioritized. It will not be discussed in the life of this parliament. And so we have to engage our member to begin to see that it honors God when they offer themselves for leadership positions in this particular sphere. And that is a campaign that we would like to run as the Evangelical Alliance of Kenya. But finally, allow me to say one other thing that we are doing. We would like to see a peaceful election. Apart from credible leaders being elected, we would like to see a peaceful election. And so what we have committed ourselves to do in the launch of what we are calling our Evangel Mediation Council is to ask each of our clergy, from the national to the very grassroots, from the bishop to the parish minister, if any of them has a member in their church who is running for elections. We have prepared them and spoken to them, and we are going to do this across the country to consider pastoring these people for a peaceful election. We have given them tools, and we are going to continue to the grassroots to ensure that our pastors have capacity to pastor their members who are running for elections. And we have told them, we will not stigmatize you because we have seen you with a candidate, or we have seen you meeting a candidate, because we want you to engage them now to preempt negative rhetorics. If they have gone out for campaign, just like you meet a teacher who is your member, a doctor who is your member in church, and ask them, how was your day today? How was work today? And pray with them. You will meet the political candidate and ask them, how are campaigns today? What happened today that stones were being thrown? Are there issues that we can pray for? How can we accompany you in this process? Seek out their families and engage them and accompany them during this process. The idea is that when you do this, you increase your capacity to be able to call them to account when you need to call them to account. And so it's going to be easier for us to be able to send so-and-so to candidate so-and-so and send a rebuke without having to use media or to engage in a manner that is not honorable. And so we have invited our leaders to do that, and we are doing that at the national level. We have profiled all the candidates, and if any of them worships in a church that is a member of the Evangelical Alliance of Kenya, our bishops have been assigned to pastor them for a peaceful election, to ensure that we are carrying on a process that does not only honor the Constitution and the people of Kenya, but also honors God. And that is going to be our contribution in this process. Thank you very much.
Thank you, Dr. For such wonderful insights. Sheila?
Marcus, how do you expect me to speak after the man of God has spoken? Because I actually associate myself with the views he has shared on the issue around leaders and integrity. As Transparency International Kenya, our work on Chapter 6 started before the Constitution. We drafted what we called constitutional minimums in regard to integrity. You know what happened. The Chapter 6 was actually quite a much bigger chapter in terms of content, and quantity. But then politicians said that we don't need such a big chapter on leadership and integrity. This thing on corruption, we'll deal with it in a few years. We just need a few clauses, you know, but look at where we are now. And you all remember, for those who followed the enactment of the Leadership and Integrity Act, okay. What happened, the dramas in Parliament during the enactment, or rather the debate on the Leadership and Integrity Act in 2011, and there was a lot of adulteration on the provisions that were therein contained. And I always say we are where we are now in regard to implementation of Chapter 6 because of politicians and their reluctance to be held to account. And we now don't have a proper mechanism to enforce compliance on the constitutional provisions of Chapter 6. I think our colleague from Ibc has spoken in regard to the inconsistencies between what you have in Chapter 6 and what you have in the Elections Act. It does not have a clear pathway in regard to blocking candidates who have unresolved ethical issues. We've seen what has happened in the last 5 years, where a lot of our elected leaders have, you know, gone through the revolving doors of EACC to answer to investigations, have been active subjects of investigations. Some have been charged in court. Some have been asked by the courts, and we are thankful for the progressive rulings by Justice Mumbi Ngugi, Justice Ngenya as well, and others, asking such people who have been charged in court to actually stay away from office. We hope that that will continue to hold even for people who will want to vie in the coming elections. And I think for us, we in 2017, under the National Integrity Alliance with colleagues from Zalendo and Inuka, were able to present a list of 20 people who we said were not fit to hold office after our own research and analysis, looking at the cases in court, reports of Parliament, the Office of the Auditor General, and other accountability institutions. Unfortunately, many of those were cleared, and when you look at the number of the people who are now being investigated, the people who are now in court, they're the people we listed there. So that really validated our claims that these people should not have been cleared to vie for office, because it's not even those old cases that we listed in 2017, but they were elected and they got the opportunity to steal more resources, and here we are now. And of course, we had what EACC did in regard to presentation of 106 names. We have challenges now, but I think all's not lost in terms of how we proceed in 2022. The legislative reforms, I think, are a long shot. We know that there are current attempts by MP Opio and I to amend the Leadership and Integrity Act and the Elections Act to make them, align them to Chapter 6. For me, I think that is long term, that's the reality. And we need to look beyond the legislative efforts, even as we continue to push what we can. We have gone to court previously through the support of the Kenya National Commission on Human Rights. We went straight to the Supreme Court seeking an interpretation of Chapter 6, looking at the provisions, should we then be able to, should people who have unresolved issues be barred from vying the elections? Unfortunately, the court decided that they cannot pronounce themselves on that particular matter and asked us to go to the High Court, but we still feel that judicial intervention is something that we could still try. We spend a lot of time and resources on that. Sorry, we are still busybodies. I'm glad to be called a busybody, because for me, that is one way of just being able to attain my constitutional and achieve my constitutional rights. And so that is still an option for us. Another option is political parties. I'm happy we have CMD. We've engaged them a lot. We've tried to speak to political parties on these issues around Chapter 6. One of the calls we have made to political parties is, as you nominate, please ensure that these people actually meet the provisions of Chapter 6. It's a long shot, but we've seen some political parties, actually some attempted to do that in 2017, and it is still something that we will try and are trying to do as we speak now. The other aspect is just calling for the judiciary. We've had occasion to be able to meet with the Chief Justice, and one of the calls we made as civil society then is, can they expedite all anti-corruption cases where politicians have been charged? Because as Dr. Makanda has said, it is likely that many of these people who are currently in court will be cleared because they have the right under the Elections Act to, exhaust all appeal mechanisms. And as we stand now, there are a lot of cases in court, but what has happened is even the people who have been convicted have quickly gone to court to appeal those judgments. So that will be the situation. But we have asked, can we then focus and clear these cases so that these people have no other mechanisms to exhaust? So that's one strand, and we hope the judiciary will be able to consider that, because currently corruption cases take such a long time, an average of 5 to 7 years. That's a whole electoral cycle. And so it's something that we also need to see coming from the judiciary. I think the one last thing, as I always say, if all else fails, it's the citizens, it's up to the citizens. And as just similarly as what the church is doing, we are also engaged in a lot of civic efforts. Social vetting is one of them. We're providing citizens with vetting tools and guides on how they can vet at the local level, decampaign leaders who have been accused of corruption. We're providing them with information. We have a database where we have put in all the cases on corruption, people who have been convicted, ongoing cases, and we're encouraging citizens to use information in these databases, and we'll give that information out. And just continue to give them tools to be able to conduct this vetting, because if it's not going to be done by the institutions, they'll have, we hope citizens, and we're empowering them to be able to do that. We had the Red Card campaign in 2017 with Inukar and Mzalendo. It is something that we hope to revive, to decampaign people who have been named in corruption cases and are being investigated. Because I always say, as Lucas, you've mentioned, that why ask just people who are fresh off the university for all these requirements, clearance certificates, but then for politicians who are going to be charged in oversighting billions of shillings, there's really no requirement. We actually demand more from our house helps and guards. When you employ someone in your house, you ask more from them than you ask politicians, and yet politicians are charged to watch over much more resources. So what we have also asked our institutions, that if the law does not give those mechanisms, what are some of the administrative measures that we can take up? Can DCI, for, in terms of clearance certificates, ESCC, we saw what they did last week in terms of trying to block the nominee for the deputy Nairobi governor seat. But unfortunately, I think the county assembly said that process has since flown, and there's nothing that they could do, and that they were ready to clear. But thankfully, that case is in court. But I think ESCC, DCI, all institutions involved in terms of clearing these candidates, this is something that they can do in terms of just denying these people some of those clearance certificates. The Kenya National Qualifications Authority, we've had a lot of cases in terms of academic qualifications and the certificates that have been presented by some of these candidates. For us, that was a low-lying fruit in terms of cleaning up, the leadership scene. But that really hasn't happened, and you've seen a lot of these cases where people were cleared with fake academic qualifications. So what can these institutions do to ensure that even if the legal route is blocked, but there are certain administrative actions that can be taken? So I still hold the fact that all is not lost. There's something that we can do to use 2022 as a year when we reject candidates who have breached the Chapter 6 of our Constitution. Thank you.
Thank you, Sheila. And I think those are good insights, especially something to do with social vetting, that we even have a role to play. If the legal mechanisms fail, then we have some roles to play in terms of, because ultimately it's us who elect these leaders, and if we can impose certain moral and ethical standards on ourselves, and also we can enforce them towards others. So that brings us to a very good understanding on the place of the various sectors, whether the religious sector, the civil society sector, in terms of the roles that we play or we can play to ensure that we present to Kenyans leaders that can be trusted, leaders that can transform their lives. To bring us to the conclusion of this segment is a discussion around inclusion. Inclusion in terms of political party processes and other related electoral processes. And in the panel, we are joined by Nyang'ori, who is the Executive Director for Semiride, and they've been working very, very closely in working around inclusion of people that are ordinarily left behind, the minorities. And as you come, Nyang'ori, is to focus primarily, why is it that we repeatedly exclude these people in our processes, and based on the lessons that have been learned, and suggestions and recommendations that have been made, what do you think must be put in place to promote within this timeline that is left? I'm told we have about 200 and how many days? 260 something days to the next election. What can be done practically to improve the participation of these Kenyans in our electoral process, and especially things to do with social perception regarding that area? Welcome.
Thank you, Marcus. Sometimes it's very difficult to be the last person, especially when everyone is restless to live. As Marcus has said, my name is Nyang'ori. I work for the Center for Minority Rights Development, and probably I'll just start off with where he left. Why are certain segments of society always left behind? That's a very difficult question to answer. I wouldn't say that I have a ready answer to that, although it all has to do with systems and the architecture of processes. And the first point to start, I think CGD mentioned a bit of this, it's really the question of definitions. One of the things that comes out very recently, for instance, is that one of the duty bearers, the National Gender and Equality Commission, undertook a process. And in this process, they decided to map out minorities and marginalized communities, and decided to actually redefine the whole concept of minorities and indigenous communities in Kenya, to the extent that if other agencies, duty bearers, were going to use that definition, then the marginalized communities and minorities would actually further be disenfranchised, because they've decided to apply the English definition and not what is in Article 260. So you end up creating situations where communities who are meant to be provided affirmative action for under Article 56 and 260 of the Constitution would further be marginalized in their own areas. Now, probably just to bring us up to speed with the whole concept of minorities and indigenous peoples, and this one I say because seated here the whole day, listening to the conversations, it actually is very clear that nobody from among the duty bearers is really focusing on minorities. When we talk about marginalized, we talk about marginalized groups. However, the Constitution is very clear that we have marginalized communities and we have minorities. And among these marginalized communities and minorities, we actually have those marginalized groups. We have women among these groups. We have persons with disabilities who actually face even more serious challenges when they're not targeted properly. So who are minorities in this particular sense? And I think there was an attempt by Masime to focus on this, or kind of give an explanation. For us, within Semiride, we look at communities that are in non-dominant position, and this could be religious aspects, in ethnic, especially where communities As we speak, there are communities in Kenya who are Kenyan citizens, but they have been denied citizenship, so they cannot participate in these processes. Or we even have linguistic minorities. Marginalized communities or indigenous peoples actually as identified in Article 216. The Kenyan government has acceded to this. So one of the most interesting bits when we're talking about political processes is that during its most recent report to the ICCPR, the International Covenant on Civil and Political Rights, the government acknowledges that indigenous peoples who are actually marginalized communities exist in this country, and therefore there must be special protections for them. But when you come to the processes that are being done by the government, this is not being achieved. So one of the issues here about inclusion politics is that there's that very clear lack of recognition of existence of minorities by the people mandated to implement the Constitution of Kenya in this particular aspect. And probably one of the biggest problem is that the staff in these institutions may not be interested or may lack capacity, technical capacity, to then engage with this subject, because this is a concept that is new to Kenya. I think it starts getting ground after Constitution 2010 is enacted. And therefore we have most of these communities. And when we talk of these communities, as said, we are talking of communities with citizenship issues. At the last count, communities that were claiming citizenship in Kenya who did not have citizenship status were almost 5 million. That's a very huge population to be left out or be disenfranchised in processes. We have communities like pastoralists, we have the forest dwellers, and we have the fisher communities who identify as indigenous peoples. There are a number of issues, and one of the biggest issues that these communities face is poverty. So when we're developing programs, poverty, they occupy very, very desolate geographical locations. So when you're defining programs, then these programs must be designed in a way that will enable these people to engage in processes and not be politically excluded. And 2 or 3 things that I want to mention here. ORPP has mentioned, for instance, that they are moving party political registration to a digital platform, which is a good thing. However, how many Kenyans are able to access digital platforms? It's good to digitize, but we think that digitization should also be done with a lot of care, with a lot of consideration. Because when you go to the census, Kenyan census 2019, you find very interesting figures that in a population of 15 years and above, according to the census, only 4.3 of the Kenyan population and above used internet for browsing purposes. 4.3 of the Kenyan population, 15 years and above. Among some of the communities that we're talking about, in Tana River, the percentage is 1%. Garissa 1.6, in Turkana 1%, in Busia 1%. I think the highest was Narok, which was 1.5%. Now, with these kind of figures, and you are forcing everyone to use digital platforms, what are you actually doing? You are practically disenfranchising people directly. I mean, the fact is that, yes, we want digitization. COVID-19 has brought new realities. However, we must do it in a way that we are able to put in place programs that will make sure that we do not leave out people, we do not exclude people from participating or from exercising their right to participation. I've mentioned the issue about ID cards. where a section of Kenyan ethnic minorities still face discrimination. We still have cases, for instance, among the Nubians, where somebody born in Machakos, who is a Nubian, is being asked to come to Nairobi, to Kibera, to be able to be vetted. This person has been born, has gone to school in Machakos. Why would he or she be forced to come to Kibera for vetting to get an ID? And by the end of the day, they'll not even get that ID within the specified period. And we have millions and millions of people who are experiencing this. And lastly, of course, the lack of legislative architecture to enable inclusion. And very specifically here, in relation to Article 100, it's never been implemented. It has provisions on how, on inclusion, on special representation mechanisms. Of course, it's been mentioned that there is the SIG's bill that is going to be given the second mention. Would want to get the support of all of us here so that we push very specific quotas for minorities and marginalized communities. Because all along, when we talk about SIGs, most people tend to think SIGs are just the groups that we talk about: women, persons with disabilities, and youth. However, we have minorities and indigenous peoples included there. So let me just look at what is it that should be done. Of course, the Article 100 is a priority before elections to make sure that we really have very specific provisions. And the other thing, as we look at Article 100, is would want to caution against the duty bearers, against rushing to redefine, because we do not understand the concept, we want to redefine it. It's actually going to cause more harm to minorities and indigenous peoples. Let's go back to the Constitution and use the definitions that have been given in the Constitution. Ibc has spoken, and would just like to note that we still need to do a lot. There is lack of regulations by the Ibc, and I think it's been noted here on how political parties should comply with the constitutional quotas, specifically on minorities and marginalized communities. And I think when it comes to this, it's important to just make a clarification that it doesn't have, we don't have to force existence of minorities. I think that is what is disturbing us when we're trying to implement these laws. There are certain criteria that are used for identification of minorities, marginalized communities. Let us not force existence of minorities where they are not there. So we need to really realign our laws so that where minorities, indigenous peoples, or marginalized communities do not exist, let us not force their existence. I think that is what is disturbing us when we're implementing this. So when we want to uniformly apply these kinds of laws where affirmative action is concerned, we end up actually damaging the gains that have already been made. I think just like it was done with the marginalization policy when it was changed, the first policy was very clear, aligned itself to Article 260. The second policy, we tried to create, we tried to force onto the podium many more marginalized groups so that they can also share with the gains or the resources that were meant for the equalization fund. Digitization, as I've mentioned, should be done in phases with a deliberate focus to ensure that minorities and indigenous peoples are not disenfranchised. And that means, apart from that, all the other bottlenecks, party registration issues, party nomination issues should be dealt with to ensure that the rights of everyone to political representation and political participation is achieved. Targeted voter registration drives, where Ibc registration of persons should work together. Properly designed civic education materials because of illiteracy levels, and captured within the policy and legislative platforms. The issue of dispute resolution, I think, has already been mentioned, where a lot of dispute resolution is centralized. And that means that members of minorities and indigenous peoples who actually in remote areas cannot access these structures, and they end up being left out of political party processes. And finally, the whole question of resources. Many of these communities face challenges of resources. There needs to be a mechanism, a very deliberately designed mechanism by the duty bearers, either Ibc, the political party's office, to ensure that the members of minority communities or indigenous peoples who would want to participate in political processes are not inhibited because of lack of resources. I think I would leave it at that point because of time. And I hope that as we move forward, we'll all work together, especially with the duty bearers, to ensure that we do not dilute the gains that were already made for minorities and marginalized communities in the Constitution of Kenya 2010. Thank you.
Thank you, Bwana Nyang'ori, for those wonderful insights. I think we've come to the conclusion of that segment. During those discussions, we were able to highlight some of the key issues relating to human rights, approach to electoral process, and of course, ways in which political parties can be used as vehicles to realization of social and particularly the political rights of us as Kenyans. But also from the discussions, of course, we've been able to be informed about leaders as servants of God. Of course, it reminded me of former titles of the Pope. Father, you could remember in the medieval times, the Pope used to call himself the servant of the servants of God. I don't know at what point that title was dropped, but the fact that we only see church leaders or religious leaders as servants of God, but ideally leadership is because you're serving the people, and if you see the people as coming from God, then you're really servant of the servants of God in that manner. But of course, Nyang'ori also raises critical concerns about programs and how they ought to be designed in a manner that responds to the various needs, especially of the marginalized and minorities. And of course, cautioning us that the definition of minorities should not be changed in a manner that spoils out the intention. So with those very many remarks, but very good points, I would like to thank the team that is present here for creating time and for giving us very wonderful insights, which will inform the practical steps that the leaders will be speaking to tomorrow. So thank you very much. Could you give them a round of applause as they leave the stage? Thank you, guys. So now we're coming to the near close. So just hold on a little bit. We move into, no, I'm saying the team. Thanks. So we're coming to the end. We're coming to the end of our discussions, of course. We move into a very short plenary. If there are any fundamental and burning questions, this is the time to have them addressed. So if someone has something that they want to address, this is the time We have one there. Okay, so then.
Thank you very much. Let me assist Marcus from here on. We want to close as soon as possible. I was actually advising that we should just go ahead and close, but because we have not heard from the plenary, I saw one hand. Let them be burning. We are not asking questions. You give your very short remark on some of the issues, something which has been missed out during the day, and that can be able to form part of our report. So I only see one hand. Okay, so let's have somebody take a mic to him. We get to hear what he has to say, a contribution to this. It's been a very long day, but I think it was very worth it. We've heard from different stakeholders in terms of some of the issues that we were saying in the morning that we needed to take stock of. Tomorrow we shall be having a leadership meeting for the partners who put this together, with the purpose of trying to, consolidate everything which was being discussed today, as well as be able to draw up a communique that can be able to give to the public that speaks to the plans or the action points that we'll be looking at. As stated in the morning, as we wait for him, I think he's already gotten the microphone. So let's hear from you first. Thank you.
Thank you very much. My name is Josephat Mutua Waema. I have a burning issue, and this one I'm directly taking it to the IEBC. Last voter registration drive, which was on October this year, there were some things which I considered unconstitutional. For example, I'm giving an example with me. I'm an aspirant in Ngara Ward, MCA. So I had shifted from Kariombang South Sivo to Ngara. So when I went to change, because I used to vote in Makueni and to find in Makueni, when I went to register as a voter in Ngara, there is something which was unconstitutional, which was applied to me, although I succeeded later on, and it was not only me. There was this question of being told by IEBC officers to produce a letter of proof of residence that you have been in that place for more than 9 months. Although the national coordinator said we are not asking questions. May I get clarification from the IBC? For example, if one shifts from the river to Lavington, and then you are told to produce a letter of proof of residence from the chief and you don't know the chief, isn't that a violation of the political right of an individual? So I think the IBC must not allow that thing to happen, because later on I came and registered. But where I registered, people were bad. I registered as a result of being violent, because I told them if they won't register me, I would head to the office of Chebgat. Then somebody told, come and don't tell the others. Isn't that corruption? Thank you.
Well, thank you very much for those comments, Josephat. And I think you did the right thing at the end. I mean, the part of it is that there is citizen agency in that, but there is, of course, issues which IBC still has to sort out as far as registration, transfers, and all those other issues. I think one of the problems that we've also faced as ELOG and other partners in this is that when it comes to some of the information which goes to the lower ranks or in the different offices of IBC, it is not consistent. And I think that's something that we're going to be picking up in the conversations that we're going to be having with IBC. I know they are not in the house, so we'll pick up those conversations from that concerned Kenyan, just to ensure that the processes are all corrected. I want to come to the close of this session, because I know it's been a very long day. Everybody has been holding on to this particular final moment. We have been in a room which has been very chilly also. People have been using a small excuses just to get outside and get some sun and come back. But it has been all worth it because of the environment that we are in. I want to take the opportunity to thank everybody who has come, who has graced this event. We put it as it's a partnership issue. You can see from the banner that is in front of you, all those partners who've been working together, Mzalendo, we worked with the Siasa Place, with the Editors Guild, Transparency International, LGIA, Center for Minority Rights. There are many, Center for Multi-Party Democracy. We were partners who have been sitting and who've been working together for the last 2 months to ensure that this has worked out. I want to thank the Secretariat that has been putting this together. They've worked a lot. Kenya National Commission of Human Rights for hosting those meetings, which were conducted over the flurry of activities and meetings over the last 2 weeks to ensure that we got ourselves to this point. The announcement that I wanted to make was that tomorrow is a day, like I said, for the partners to be able to put down everything together and to be able to issue a public communique. So all the partners are invited to come back here, perhaps in a smaller room, smaller convening, to be able to put our ideas together, all that has been gathered today, and then we can be able to speak to the public about it. But we also want to make a further announcement that this is the second State of Electoral Preparedness Conference. We still have 2 more before the elections, and we shall be convening Kenyans at strategic points between now and the elections to be able to bring the conversation to the people, listen to the stakeholders, be able to listen to other actors, the civil society, the churches, and the duty bearers, so that Kenyans can remain appraised of the preparations towards the 2022 elections. I want to call everybody to be upstanding so that we can be able to close this session with our national prayer, which is the national anthem. And then we can be able to close the meeting. Achieng, do you want to come and lead the session like you used to some time back? At least the baby can also get to be in a prominent, play a prominent role at the end of the session. Let's appreciate this family. You know, they have this is a Cheng. We work with her very closely, and she has 2 daughters who have graced quite a number of ELOG occasions, by the way. This is, I think, the biggest one of them. They have been able to come to Bomas to lead Kenyans in discussing issues about the preparations for the elections. Wacha watuongoze kwa wimbo. Mina unaweza anza kuimba wimbo wa taifa. Si unajua vile naenda? Haya, saidia watu kuimba wimbo ya taifa.
O God of all creation, bless this our land and nation. Justice be our shield and defender. May we dwell in unity, peace and liberty. Plenty be found within our borders.
Thank you very much. Pigeni makofi. Sorry, I still think there's still tea outside, so please grab your cup of coffee or cup of tea on your way out. Any other announcements, Marcus? So we are good. Thank you very much, and journey mercies as you go back to your places of dwellings. Sorry, there's one particular team that we have not said bye to, which is our online participants. I want to thank them a lot. Sorry for forgetting you. Let's clap for our online participants, please. They have been part of this team. We had quite a number of questions. I think they gave also a number of comments, which we are going to put into consideration as we compile our report. Thank you very much from wherever you are watching us from, all the 10 regions from ELOG, and anybody else who was participating in the process. We thank you.